commenced.
Good morning, everyone. Hello, I'm Dr. Shobhini Chatterjee. I'm the founder CEO of SRTD Group and Vidhi Varta. And very good morning. It's a lovely Sunday morning, and thank you all for giving us an hour from your busy schedule. And thanks specially for our special guest and our resource person for today's expert talk is Dr. Raghunath Chakraborty. Today we will be having a very interesting discussion on the topic Indian insolvency law and analytical discussion. This is very important topic for those who want to understand insolvency laws, the current trend of insolvency laws in India that is persisting right now. Many students they're very much interested in pursuing insolvency laws in their upcoming trimesters and semesters in their law schools. So to start, I'll give a very brief introduction of Dr. Chakraborty. Though it's a very short one, I hope I had a longer introduction for sir, aligning with his great achievements. So Dr. Raghunath Chakraborty completed his BA LLB in the year 2010 from Tripura Government Law College under Tripura University. He has completed his LLM from Hidayatullah National Law University, Raipur in 2014 with specialization in corporate law. He has completed his PhD from National University of Study and Research in Law, Ranchi in the year 2022. He has enrolled as an advocate in the Bar Council of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, Arunachal Pradesh and Sikkim since 2010. He has worked as an intern at the WBNUJS Calcutta High Court and also practiced at Agartala High Court. His academic career started in the year 2017 as an assistant professor. Dr. Raghunath Chakraborty takes keen interest in organizing and judging national and international notebook competitions. He also takes interest in publications and attending national and international seminars or webinars in his arena of interest. His areas of interest include security and investment laws, bankruptcy law and competition law, banking law and taxation law, criminal law and constitutional law, to name a few. We are very honored to have you with us, sir, and I hope the audience will just thoroughly enjoy your session today. It's all over to you.
Thank you, madam. Thanks a lot to Madam Shomi, madam, and also to Vidhi Varta for providing this opportunity. And actually, before starting of this discussion, I am just giving one brief short discussion on this topic, because insolvency law is such a vast area. It is not possible to complete within the short period of like 1 hour or 1.5 hours. But what I am focusing, that is the development of insolvency law in India from the very beginning, and afterwards that what we find in 2016 and when this IBC code came. So my discussion, it would basically focus on the Indian insolvency law till the development, and we'll focus up to a period like after COVID part, what is the impact of that, because that research is always it is developing and it is not any end. So that's why, and but I can assure that this discussion will definitely give some way forward in this subject for the academicians as well as for the purpose of professionals also, as well as practitioners also. We can at least identify what are the focused areas that we should give focus, and government also, because when we are going to discuss something in nowadays in law schools, that is also going to be one reference in case of lawmaking. So now that is known, earlier I have mentioned Indian insolvency law and analytical discussion. The contents that today I will cover, these are going to focus on the introductory part of the discussion, general meaning of the terms and the origin and early history of insolvency law, the various key provisions of the IBC Code or Insolvency Code 2016, insolvency laws which are applicable to this country, the enactment of the particular law, under what circumstances this code came into existence, what are the various important aspects, various important pillars of this code. And basically it will focus on the regulatory mechanism and regulatory bodies. Then initiation of corporate insolvency, because actually this topic is focused towards the corporations and their commission of what we can say that they are committing their defaulters. So in that case, what may happen? So corporate insolvency resolution is one of the basic need of the society for now, and we will focus some of the important cases. Then the legal amendments took place in 2019 and impact in the suits, and with that I am going to conclude with my conclusion. So in the introductory part, we can say that this code, Insolvency and Bankruptcy Code, it is the only one law applicable to the Indian system now, that is IBC Code 2016. It aims to consolidate the existing legal framework and establish a single law for insolvency and bankruptcy. Basically, the objective of insolvency and bankruptcy
Sorry
is to
interrupt you, sir.
Yes,
So your
yes.
slides are not moving. If you can just
They are not
make
visible.
the screen. They are not moving. As in, please make the slides on full screen mode so that it is more visible to.
Madam, now is it visible?
Yes. Now it is visible.
Okay. So now that the objective, if we are going to focus of the IBC, it is to streamline the existing framework by repealing the Presidency Towns Insolvency Act. Presidency Towns Insolvency Act was applicable even before independence in 1909, and the Provincial Insolvency Act in 1920, and later on, because India was under the governmental system, that means we can say before the privatization, globalization and liberalization, these concepts came into Indian economy before 1992. Till 1992 we can identify, till the Manmohan Singh era, when Dr. Manmohan Singh became finance minister. Before that, India is actually running under the government system, public companies and various other things which are licentiated. So one such thing is that the Sikh Industrial Companies Act of 1985, which came into existence to develop the condition of the Sikh industries. So these are the things, because Sikh industries are also dealing with the various unpaid amount of debts, and if a company has taken loan and it is unable to pay back the debt in proper time, then automatically that will create some non-performing asset in the economy, which is known as NPA. But that NPA concept came later on. So if we can identify what are the laws were that, regulations were that only, that the earlier independence, the Presidency Towns Insolvency Act applicable to all the Presidency Towns, Calcutta, Bombay and Madras, and afterwards that the SICA 1985. And after that, when on 29th of August 2013, our Companies Act, the recent Modern Companies Act came into existence in 2013. So up to that, these are the laws. Now, for recovery of debt, because insolvency, when this thing came, the concept of insolvency came when someone, it may be a natural person or it may be a corporate body, or body corporate, or that artificial juristic person is unable to pay back the loan. So recovery of debt due to Banks and Financial Institutions Act of 1993 and the Securitization and Reconstruction of Financial Assets and that Enforcement of Security Interest Act, SARFAISI Act in 2002. So these were few things. Not in, we can say, before the IBC Code came in 2016, there is no comprehensive law, and these were the laws, and till now some laws are in existence. The system, the government is trying to deal with the particular concept of insolvency, which is actually not proper. Now, when this law came, if we can come into that point, that IBC regime in India that go through a specific legal process which involves several stages in legal forums, such as the National Company Law Tribunal. National Company Law Tribunal, that is a system. It is a quasi-judicial body, but it is actually dealing in the company law. That is the highest authority in case of companies. So where a creditor files a petition for initiating insolvency proceedings against a debtor, that is through the National Company Law Tribunal. That is the corporate insolvency process. Now, National Company Law Appellate Tribunal is dealing a higher forum where parties can appeal against orders passed by National Company Law Tribunal, Appellate Tribunal, NCLAT. And next one is the Supreme Court of India, Honorable Supreme Court. If the thing started from National Company Law Tribunal, then the highest part is going to be the apex court, that any person aggrieved by any order of the NCLAT, National Company Law Appellate Tribunal, may file an appeal to the Supreme Court. So this is the common system of procedure that one should adopt in case of the insolvency. Now, as we have started with the background as it is different from other discussions. Background started with the legal regime, because definitely today's discussion of mine is focused on this topic, that is the legal regime. But what is the general meaning then? Because I feel that some of them who are here as audience, you are students. So the concept of insolvency or the meaning of insolvency, actually the inception is there in the Black's Law Dictionary. If you can find the meaning in Black's Law Dictionary, the term insolvency refers to the inability to pay one's debt or one's loan. The modern business environment is heavily dependent on use of credit by the companies. And without this, even some of the particular funds like venture capital fund or venture capital companies, they have been created to support that. Even government is also there. Nowadays, when we are speaking today in this era, that already 1% company, already the concept of startup, already the concept of that MSME and Make in India, Atmanirbhar Bharat, these things are in line. So if we are going to accept the support, so government, this support, giving support through loan, that is a very common concept. And that started through the villages when the self-help groups, they are getting loan from the government with a small or very simple interest. Now, in this process, there is a high degree of risk incurred by the creditors. In fact, the entire economy may come to a standstill if this credit cycle is stopped. So that is the thing, that credit cycle is there, and credit cycle should not be stopped. If someone has taken the loan, he must have to pay back the loan. If it is not going to be paid back, then automatically it will create some bad debt or non-performing asset upon the economy, which is a burden. So insolvency law seeks to protect the interests of the creditors in the event of any sort of default by the corporate debtors or the company. In fact, one of the major aims of the insolvency law is to replace this free-for-all regime with one in which creditors' rights and remedies are suspended and a process established for the orderly collection and realization of the debtor's assets and the fair distribution of these according to the creditors' claims. So this is a very good condition what has been mentioned in the general meaning. Generally, it is not going to happen. So if we can give focus in the next slide, that in the origin and the development of the early history of the insolvency law, then the concept is not new in India. It is not new. Insolvency and bankruptcy, they are two related but distinct concepts. While insolvency refers to the inability to pay debts, they become due. Bankruptcy is the legal process that results from insolvency. So insolvency is the process and outcome is going to be the bankruptcy. In other words, insolvency is a state of financial distress that may lead to bankruptcy. So bankruptcy is the ultimate that is going to happen. So that is the common concept, common figure out of the meaning that is in case of insolvency and bankruptcy. If we can go for origin and early history, we have to focus on our own Dharma Sutras, Dharma Shastras, ancient Hindu system. We can go for the Sanatan system, what we can nowadays repeatedly use, that Sanatan Dharma. So, according to the Dharma Shastras, failure to repay the debts can have a severe consequence. One is loss of reputation, and it is not for only for the today's perspective. If we can go for the earlier one, means the age of Dharma Shastras, in those days also, Manu Samhita, or afterwards, that when we will discuss about, every time that Dharma Shastras is clearly mentioned that taking loan and non-paying the loan is one of such thing which will that defaming, and therefore it is considered a moral duty to repay one's debts, and various remedies and penalties were prescribed for those who default on their financial obligations. So the Dharma Shastras are a collection of smriti or texts, we know that, as per the Hindu law, that were authored by the sages in ancient times to provide guidance on ethical and legal principles in Hindu society, and that is treated as Sanatan Dharma nowadays. Now, if we can go for Dharma Shastra, some words being used. They have given that that if a person dies without repayment of debts, his or her debts, that unpaid debt or unpaid loan will have to be paid in the next life by serving the creditor as a slave. So these were shown also through some pictures, and this is only to make aware that if you are going to do, if you are going to commit such default, then this thing may happen with you. This cycle of servitude will continue until the debt is fully discharged, and the person will not be able to attain the salvation until the debt is paid off. In the ancient Hindu legal system, the concept of Kusidin was a concept that was used to refer a creditor. Creditor is known as Kusidin, or a person who lends money. In ancient Hindu society, money lending was a common practice. In Kusidin played an important role in the economy. So this is generally history starts, we can say that prehistory periods are also there, and as per Hindu system of law that came from Manu Samhita, Dharma Shastras, Dharma Samhitas, so we have to refer them. However, the charging of high interests by Kusidin, that was also a cause of concern, and Hindu law provided for regulations also to ensure the fair practices in lending and borrowing. Now, in that case, what we can say in modern day, as per the insolvency and bankruptcy, we will find some words like resolution professional. So in ancient Hindu society also, such types of resolution professionals were there, and that is mentioned to determine the extent of the borrower's assets and liabilities, and for their settlement, a person known as Bevaharik, his name was Bevaharik, he was appointed, and thereafter it used to be taken up to the king for resolution. The role of the Bevaharik was akin to the present day's resolution professional. So there is if we are going to make a comparative analysis, then these things are always important. Historical studies, you cannot ignore them. In the next phase, that when Kautilya, when we are going to refer Chanakya, Kautilya, his Arthashastra is a very famous system of law as well as economics that was done by him. So another suggestion made in the Arthashastra is the establishment of a debt relief fund, which is akin to nowadays interim finance. Nowadays we can find one term known as interim finance in 2016's code, and it is taken from the Arthashastra itself, Kautilya's Arthashastra. This fund would provide financial assistance to insolvent debtors who were unable to pay off their debts. And if we can go for the Mughal period, one of the best that administration after the Maurya period is in the middle part of that is Middle Ages also. And that point of time, Akbar, one of the foremost, is the known figure amongst all these Mughal emperors. So as per his system, as per the suggestions of his finance minister Todarmal, took various measures to address the issue of insolvency, such as appointing officials to supervise financial transactions, and that is the establishing courts to settle disputes and imposing penalties for fraud, etc. So it is like our modern day liquidator in companies. He is dealing with that. So these are nowadays we are using different terms, but if we can go from the historical evaluation, it is there. The insolvency, the concept of insolvency, it was there, and the people, how they are going to find out the way to deal with this. That chain is there. Now, during Mughal period, one was another thing, that loan agreements called dastawez, which dastawez in the talab, which was payable immediately, and dastawez miyadi, which was payable after a specified period. So these are identical terms of documents against payment, that is DP, letter of credit, that is LC, and document against acceptance, that is again we can say DA. So these are all being used in the modern banking system, which were prevalent in the Mughal period. So all these ages, the growth of insolvency law in India, it is a subject matter of history, and we have to accept this. Without accepting, we cannot come in today's picture. Now, insolvency laws in India, if we can take as part as a law, as a regulation, then insolvency law in India is definitely based on English law, English legal system. They have done their colony for near about 200 years. We know everything about them. They came as a corporate body and they became the rulers. So insolvency law in India is based on English law. That English law need for a legal framework to deal with insolvency, that was first recognized in India's 3 presidency towns, which I have already been discussed, that of Bombay, Calcutta and Madras, where British engaged on trade. Sections 23 and 24 of Government of India Act 1800, even before independence, the Indian Insolvency Act 1848 and the Presidency Towns Insolvency Act 1909, the first insolvency regulations which were there in India. But actually insolvency as a subject matter in discussion, when India was in the reform period, that is the reform started in India in the 1990s, focused on freedom of entry, and it ushered in liberalization, privatization and globalization. It dismantled the license permit quota Raj, when discretionary license gave way to an entitlement of registration, and more so, it allowed firms meeting eligibility requirements. So fixed eligibility is there to raise resources without requiring any specific approval from the state to facilitate freedom of entry. The reforms in the 2000 era focused on creating a free and fair market competition, which is also, because insolvency law, we cannot segregate it. It is a core part of corporate law. Corporate finance is there, and definitely competition law is there. So 2000 era is giving that priority to the foreign competitors to come and to do business. And in 2002, the Competition Act came into existence. So it moved away from the control of monopoly of firms to promote competition among firms at the marketplace. Then the size or dominance, that was longer considered bad, but its abuse was, and the reforms provided a level playing field and competitive neutrality, and prohibited firms from restricting the freedom of other firms to do business. So one cannot play or create hinder in the way of another who is willing to do business, who is willing to do his profession, who is willing to serve, because now service sector is again going to be a ever growing sector in India. So these are all about the starting or inception. Now that several attempts were made also to provide legal and institutional machinery dealing with the debt default, and that's why we have mentioned about the debt recovery tribunals also. Special laws such as Recovery of Debts and Bankruptcy Act 1993, Securitization and Reconstruction of Financial Asset and Enforcement of Securities Act, SARFAESI Act 2002. So, but they are not able to give the answers of the issues of the common people as well as the common corporations, because that those who are paying the loans or those who are the creditors, for both of them, these laws were not the solutions of the problem. Now, in that case, the thing that the Insolvency and Bankruptcy Code came in 2016, but it came into existence in the backdrop of all these unsuccessful experiments which were done earlier. Because there were stressed assets in the banking system, which already I have mentioned about non-performing assets, reached unacceptably high levels by the end of 2015. You can see the mention of the year 2015. And by September 2016, it reached about 9% of the gross loans of all banks and 12% of gross loans of public sector banks. So you can understand how much our system, our banking system has dealt with all these NPAs, which accounted for more than 80% of total non-performing assets or NPA in this system of banking. By providing loan and for non-payment of loan. That next is going to be on the corporate side. Major companies were operating with an interest coverage ratio of less than 1, implying an inability to service debts obligation. Thus, what emerged in popularly referred to as the twin balance sheet problem, where both the banks and the corporate were reeling under the stress of bad loans. It is not only the companies who are unable to pay back the loan, the banks who are not able to take that particular complete their non-performing asset, because they are under the pressure also. So in both the sides, economy, the gross domestic product, GDP, everything is under a big challenge due to this. And I am not going to refer any specific name of company, but you can see what happened in 2015. A premier bank like State Bank of India paid a renowned company and its owner, but he left India, and it was due to that only debt recovery tribunal, and because his assets were seized, all these things. Now, till now the legal procedure is going on, but he has taken the particular privilege of staying in some other country. India is trying for extradition and all, but till now he is not under our jurisdiction for running the system, because whatever his assets that were done, but for punishing him, there is no other scope. He is still now not under the legal surveillance. So these are the things that actually, what is the importance of the insolvency regime in India when we are going to discuss. So these are the history that some of the experiments were not able to fulfill the will and wish of the people. Now, what are the important aspects of this existing insolvency regime after bringing it into the system? That is also very interesting, that the enterprise value of the firm that reduces exponentially with the time, as prolonged uncertainty about ownership and control and general apprehension surrounding insolvency may make the possibility of resolution remote. The code mandates closure of resolution process in a time-bound manner to preserve the value. And resolution entails commercial as well as adjudicatory decisions, because the insolvency resolution system is depending on its adjudicatory mechanism, which we will discuss in the coming time. And resolution entails that commercial as well as adjudicatory decisions. The code empowers and facilitates the stakeholders of the firm and adjudicating authority to decide on matters within their respective ambit expeditiously. The code empowers the committee of creditors, which is an important aspect in the business of insolvency now, as per the law, to take all commercial decisions. So these are the two important aspects, and it is not the end. A firm is financed through equity and debt. So equity that means the ownership and debt. So when we are going to say about equity means share and debt means debenture. So if debt is serviced, equity has complete control of the firm. When the firm fails to service the debt, the court shifts control of the firm to the creditors for resolving insolvency. And the code moved from debtor in possession model to creditor in control model, because creditor, they are losing their interest, they are under also compulsion that they are not getting back their amounts. So that's why the code moved from the debtor in possession model to creditor in control model, which is an appropriate term. And from any of the specified disabilities from submitting a resolution plan should be given, and that is with all the approval of the committee of creditors and all the resolution professionals. They have to act. So there is a credible threat if a firm undergoes CIRP, compulsory insolvency resolution process, that is the full form of CIRP. The control and management of the firm may move away from existing promoters and managers, most probably forever. So these are the things that actually we can say the various aspects or various things which when this new company, new insolvency code came into existence. At that point of time, the legislature, the other stakeholders, they are going to think that why this law is actually going to be in picture, what is the reason behind that, and what is the ultimate thing. So these are the important aspects of corporate insolvency regime. Next is going to be the important pillars. Important pillar means upon whom the IBC is depending most. So the first pillar of the Insolvency and Bankruptcy Code is the institutional infrastructure. The insolvency professionals are the part of that, and IB or insolvency professional is the most important component of the ecosystem. IB is a regulated and licensed professional responsible for managing and overseeing the corporate insolvency resolution process or the liquidation process of the this particular thing, and resolution and bankruptcy process for partnerships and individuals. So corporate debtor, CD means corporate debtor, and insolvency professionals form a crucial pillar on which the entire edifice of the insolvency and bankruptcy process rests. Also, they are aided in the insolvency resolution, liquidation and bankruptcy process by information utility, which form the second pillar of the institutional infrastructure. The particular information utilities are regulated and licensed repositories of information relating to the corporate debtor. So when you are dealing with any corporate debtor, you have to think about who is the corporate debtor, what is his financial condition, what are the financial assets, what are the things in India, is there any part that is not been given in the picture, something is hidden, so that also you have to find out. So information utility services collect, collate, authenticate and disseminate financial information which is to be used in insolvency resolution, liquidation and bankruptcy procedure. So that means what is the ultimate? That when a company is unable to pay back the loan, that is the duty to find out what are the assets left and to go for the compulsory bidding, and then whatever the things came, whatever the outcome came, to distribute equally amongst the particular person who are the creditors. And most importantly, who is the prominent person as a creditor who took that initiative, upon whose initiative the resolution process is initiated. So these are the now some more points. The judicial oversight of the IP is provided by adjudicating authorities. Third pillar of the IBC, institutional infrastructure. Then the particular specified authorized adjudicatory bodies, that are specialized tribunals tasked with ensuring that insolvency resolution, liquidation and bankruptcy process is being performed. So earlier we have discussed about National Company Law Tribunal and Appellate Tribunal, and Debt Recovery Tribunal and Appellate Tribunal. Now the fourth pillar is the regulator, that is the Insolvency and Bankruptcy Board of India. Now day by day, after the code came into existence, this IBBI, in short, those who are Also professionals, you must have to note down about the Insolvency and Bankruptcy Board of India, which is acting here, which is actually dealing with this as a fourth pillar, as a regulator of the system. Then next is the regulatory mechanism of regulatory bodies. So we have already discussed about the Insolvency and Bankruptcy Code 2016. If we can trying to find out the regulatory mechanism, then there are Insolvency and Bankruptcy Board of India. Then that board is one thing, and another is the adjudicatory authority, where we have mentioned earlier about National Company Law Tribunal, National Company Law Appellate Tribunal, then Debt Recovery Tribunal and Debt Recovery Appellate Tribunal. So Insolvency and Bankruptcy Board of India, it is having three diameter thing like Insolvency Professional Agency, Insolvency Professional and Information Utility. Now few minutes back I have discussed. Now we will give a complete picture of all these bodies. So if we are going to take like IBC, the premier body, then Insolvency and Bankruptcy Board that will be established by the central government under section 188 clause 1 of the IBC Code 2016. That is the legal provision, and board means the Insolvency and Bankruptcy Board of India, established under subsection 1 of section 188, section 3(1) of Insolvency and Bankruptcy Code 2016. Board will have powers of civil court because it is a adjudicatory mechanism. We can say that it is dealing with the system. It is not dealing like the pure court. It is having some powers like that of a civil court in respect of issuing summon, discovery and production of the books and accounts, balance sheets, inspection of the books and registers, and issue of commissions for examination of witnesses. So section 196(2) of the Insolvency and Bankruptcy Code. Now as we have already, those who have studied arbitration, it is also like arbitral tribunal is not going to follow the pure legal norms. Here in case of Insolvency Board, they are not also following the pure legal norms. They are also run under some of the system of civil court as well as some of the provisions of the evidence law. So that the thing is working like that. And the constitution of board has been specified in section 189, which is dealing with the constitution of the Insolvency and Bankruptcy Code. And the board will headed by a chairperson. It will consist of at least 10 members, out of which at least 3 will be whole-time members, so that they can serve better to the board, and which is a very important body in case of dealing with the defaulters, in case of dealing with the subject matters of default. Now, adjudicating authority, we have already mentioned, and NCLT, National Company Law Tribunal, constituted under section 408 of Companies Act 2013, is the highest adjudicating authority for purpose of insolvency resolution and liquidation for corporate persons. Section 5(1) read with section 69(1) of Insolvency and Bankruptcy Code 2016. National Company Law Appellate Tribunal is the appellate authority over decisions of that body, NCLT. Section 61 of the Insolvency and Bankruptcy Code 2016. And Debt Recovery Tribunal, section 179 of the Insolvency and Bankruptcy Code. It is giving power to the adjudicating authority as this DRAT, Debt Recovery Appellate Tribunal, under section 181 and 179 for Debt Recovery Tribunal. So, appeal against order of National Company Law Appellate Tribunal and Debt Recovery Tribunal, that can be filed to the Honorable Supreme Court, Honorable Apex Court on question of law arising out of such order within 45 days. So that is going to be the adjudicating authority in proper sense. Now, out of the board's power, that Insolvency Professional Agency is one of the utmost authority whose work relating to insolvency resolution is expected to be handled by insolvency professionals. These professionals are required to be registered. It is not that XYZ can be treated as resolution professional. The professionals are required to be registered with the Insolvency Resolution Professional Agency. And that agency means any person registered with the board under section 201 of Insolvency and Bankruptcy Code 2016 as an insolvency professional agency, section 3 clause 20 of Insolvency and Bankruptcy Code 2016. Insolvency professional agencies will develop professional standard, code of ethics, code of etiquette, and be first level regulator for insolvency professional members. This will lead to development of competitive industry for such professionals. So these professional agencies are going to appoint professionals who are working for the insolvency resolution, and the professional agencies, they are coming under section 201 of the code. That means the Insolvency and Bankruptcy Code 2016 has given the scope to the insolvency professional agencies to appoint the professionals. So that's all about the professional agencies. But insolvency professionals are we can say the outcome of the code that envisages a very big role for the insolvency professionals. It is envisaged that most of the work relating to insolvency and bankruptcy will be handled by insolvency professionals. And insolvency professional means a person enrolled under section 206 of Insolvency and Bankruptcy Code 2016 with an insolvency professional agency as its member and registered with board as a insolvency professional under section 207 of the Insolvency Bankruptcy Code 2016, section 319 of the Insolvency Bankruptcy Code 2016. So all these laws, when we are mentioning about section 206, section 207 and section 319 of the Insolvency and Bankruptcy Code, the insolvency professional can be only an individual. He is an individual professional who is acting and who is fulfilling the conditions given under all these particular provisions of the IBC. And if he is not fulfilling this particular thing, particular etiquette or particular behavior, then disciplinary action against the insolvency professional can also be taken, or the agency, and insolvency professional can be initiated by the board as per the provisions of section 217 to 220 of the, because 217 to 220 of the Insolvency and Bankruptcy Code 2016 is only dealing with the provision relating to the punishment for non-fulfillment or for indisciplinary attitude or from the side of the professional or insolvency professionals. Next is going to be the information utility. So that is a very important thing, that information utility is providing the opportunity to the creditors that they should go into the subject, that what is the ultimate role they have to play. So all the information about the defaulter, about the corporate data, about the operational financial data as well as the operational data, both. Now the insolvency, now you may ask that, sir, what is financial data and what is operational data? So in that case, I want to say that financial creditors are those who relationship with the entity is a pure financial contract, such as a loan or debt security. Operational creditors are those whose liabilities from the entity comes from a transaction on operations. So these are the two concepts that correlate with this information utility. Information utility will collect, collate, authenticate, and disseminate financial information which is to be used in insolvency, liquidation, and bankruptcy proceedings. Information utility means a person who is registered with the Insolvency and Bankruptcy Board of India or board as an information utility under section 210 of Insolvency and Bankruptcy Code 2016 and section 3 clause 1 of Insolvency and Bankruptcy Code 2016. They will have to be registered with the board and section 209 of Insolvency and Bankruptcy Code 2016. So the information utility shall provide service both that insolvency professionals as well as this information utility. They shall provide services as may be specified by the board. It will also provide core services to any person if such person complies with terms and conditions as may be specified in regulations. So section 213 of the Insolvency and Bankruptcy Code 2016 has given in the information utility services. So before going into the next step, Because it is like a class, though time is very restricted. I just want to ask if anyone is having any query or doubt or anything to say.
I will request anybody who has a question so far can ask sir directly. I can see Dr. Hari Ram has his hands up. Sir, if you have any certain question, you can please ask. Dr. Hari Ram.
Okay, madam. Okay, so next process is going to be the resolution process, that is the corporate insolvency resolution process. So that is the part 2 of the Insolvency and Bankruptcy Code 2016, which basically our focused area for today, that is section 4 to section 77, which deal with insolvency resolution and liquidation of corporate persons. This part is divided into 7 chapters. As a student, if you open the book, then you will find, because this is only the thing that now I am not able to discuss like one section to another section. It is not possible also physically. But I am just giving a word of discussion with these particular provisions, like corporate insolvency resolution process, that is given from section 4 to 32. That is one thing which I have discussed till now, that the insolvency resolution process, how it is going to continue, with whose help it is going to continue. Next is going to be the liquidation process. Liquidation process means if that normal circumstances, the corporate professional, that insolvency professionals, they will try their level best to fix the assets of the defaulter, of the corporate debtor, and if it is not able to complete the debt or amount of loan is not been done with this outcome, then they can go for liquidating the company also in some cases. So liquidation process is given in section 33 to section 54, and fast track system of that corporate insolvency resolution, that is given from section 55 to 58. Fast track system is always a very we can discuss in case of criminal justice system also. When the Nirbhaya incident took place, and there is a chant from every corner that there must be some fast track system of easy redressal of the dispute. So in case of insolvency resolution also, that option been added in 2016 code, section 55 to 58. And then voluntary liquidation of corporate persons, because if some company from their core of their heart they feel that it is the proper time, like voluntary winding up should go with, and they can apply for that. So voluntary liquidation of corporate persons is again going to be a very lucrative process given under section 59. And there is also adjudicating authority for corporate persons given from section 60 to 67. There are various offences and penalties being given from 68 to 77. So all these are in together when we are discussing. So section 4 to 77, all the provisions are dealing with the corporate insolvency resolution process. Next slide, I will show a diagram. With this, I am trying to make it clear, like if there is a default from the side of the corporate debtor, then the default will bring appointment of an insolvency resolution professional, and there must be that the resolution professional must give a moratorium period of 180 days or 270 days. There is an option of moratorium. Now, what is the condition that moratorium? Moratorium is actually a legal authorization to debtors to postpone payment. The debt was to be subject to a 5-year moratorium. Now, in case of any legal debtor, any person is there, then a legal authorization to debtors to postpone payment, the debt was to be subject to 5-year moratorium. That period of 5 years is going to be treated as the temporary period to be given to the debtors for payment. Now, that is we can say about moratorium. Now, credit formation committee. How credit? So that is another step. All these are given in green tables, and then credit formation committee has given 75% of the creditors to approve, then implement the plan, goes into liquidation. So ultimately the corporate insolvency resolution, it will start from the default, and it is going to finish in liquidation, where 75% of the creditors' approval is required in the board. So this is the process in case of liquidation. But these are all the legal provisions. These will not be, we can see that without any practical experience, without any practical aspect, in law always the case laws are going to be the eye opener for everyone, judiciary as well as for the society. Now the thing is that it is a very new law. It is, if we can go, the history I have already discussed. Insolvency and Bankruptcy Code is only in the year 2016. It was enunciated when the finance minister was that is no more. Late Arun Jaitley, and he is a lawyer in sense. And when he has added this particular code or law in our economic system as a finance minister, that is a definite reason behind that point of time. Now, when we are going to discuss about the cases from 2016, there is a famous case as the Binani case. Binani Cement. Binani is a very famous name. That Binani Cement case, which had taken a lot of twists and turns, proved to be a test case for implementation of the code. In this case, Dalmia Bharat bid was approved by the insolvency resolution professional based on the primary bids, hence Ultratech Cement. These are all in picture now. These are been used in case of construction as a construction material. Now, which has been vying for an acquisition, gave a letter of comfort to Binani, which with a promise to acquire the assets at much higher amount. So, corporate finance or merger and acquisition, which is another core part of corporate law, is also interconnected with the insolvency, because one particular company like Binani is going for liquidation, and from Binani there is a chance that 2 or 3 more organizations, they are getting the chance now to seek an out of court settlement from National Company Law Tribunal. They want to do that, the Binani Cement, which was not an option available at the given time. So it is interesting to note that this out of the court settlement did not face much backlash from the adjudicating authorities in a landmark decision. The adjudicating body, as it approved Ultratech's bid, because Ultratech's bid means Ultratech is trying to buy the particular shares from open bidding of this Binani to acquire Binani Cement, which is ruled that insolvency resolution process should aim to extract the maximum value from the auction of stressed assets. So, jo chala gaya, what has been left due to the non-performing asset, the Binani, by liquidation, they are trying to gather that amount from the Ultratech company. So that is the reason of the auction. And the decision opened the floodgates to litigation by permitting Ultratech's bid, thereby opening up new avenues to the defaulting companies to find new and better ways out of an otherwise hitherto stringent process. Furthermore, the acquisition of Binani Cements by Ultratech gave the latter one, Ultratech, in addition to its earlier acquisitions, a large market share, because the shareholders are there of Binani, and competitive advantage in Western India. So now insolvency resolution process is opening the era for corporate finance, for acquisition, as well as it must go, because the next point I have mentioned that this kind of acquisition by Ultratech would have attracted the notice of the Competition Commission of India as well, because Competition Commission of India is going to make a balancing between them in the pre-IBC era. And however, this transaction more or less went scot-free due to the 180 plus 90 days time, that is as per the 2019 amendment. Now see, Binani case is a landmark case, and that's why I am mentioning this case in my presentation of a short time. Because after the Binani's rule, there was a change in the Insolvency Bankruptcy Code. There was an amendment in 2019, which is reflected in the next slide, that the Insolvency and Bankruptcy Code, that is the Amendment Act 2019, inserted 2 provisos to section 12(3) of the code to increase the time limit for resolution process, because there are chances that businesses may flourish, and to 330 days, and period of 330 days includes a normal corporate insolvency resolution period that is of 180 days, and one-time extension, if any, up to 90 days of the CIRP period granted by the adjudicating authority, and the time taken in legal proceedings in relation to the CIRP of the corporate debtor. So now this particular code is much more cohesive when this 2019 amendment took place, which increased the time limit from 180 days to 330 days in case of corporate insolvency resolution process. And this 330-day time period would be inclusive of both the time taken in legal proceedings, any extensions granted by the adjudication authority. So it is actually one opening side corporate or the business, as well as to make stringent legal aspect or law must be strong enough. Next is, there are so many frivolous cases even in a very short period of time of 9 years. Till now it is 2025. Prior to the 2020 ordinance, either a financial creditor or an operational creditor may trigger insolvency proceedings against the company. So I have mentioned about them also, who is financial creditor and who is operational creditor. Now, that in case that company after 2020 ordinance came, that either a financial creditor or an operational creditor may trigger insolvency proceedings against the company for a minimum default, even for a minimum default of only 1 lakh. And a brief glance at the current state of Indian economy would suggest that this amount is too low for being the minimum threshold for triggering the insolvency proceedings. So the current economic system, current Indian economy is of the opinion that 1 lakh is a very meager amount. When our Prime Minister is saying that our economy is going to be the $5 trillion economy. So in that period, that for the side of the businessman or corporates, it is a very less amount. So having such low threshold is detrimental to the interests of the company itself, as any company may in the ordinary course of business experience bad time. Having the minimum threshold, this low high result in frivolous litigations, which may be detrimental to the interests of the company. Now, if any company is a defaulter of only 1 lakh and the corporate insolvency resolution process is enunciated against that company, there is no ground, because that may be that the company's bad time is going on for 2 years or 3 years. That doesn't mean that its business is over. There are so many examples due to merger, due to corporate finance, due to acquisition, due to the business conditions being added. The companies who are deeming now, they are grooming also. And this problem is actually going to create hinder for those corporates who are the small scale. And I am coming into the next slide with that also. This problem may be more profound in startups and MSMEs. In case of India, which currently emerging in a rapid scale, the burden of firmly distinguishing the vexatious claims from the legitimate claims of creditors ought to fall on the adjudicating authority. So I am ending with this problem because this thing I have actually find in my this very short period of research, that definitely the IBC Code 2016 is a option for the hand of the people, the creditors, both for financial and operational creditor, to deal with the defaulters. But in that sense, that economy like India, which is a grooming economy, which is a developing economy, which is depending on the MSMEs and small scale and micro industries. So at the first glance, it may be observed that the code strives to remedy the issues such as the prevalence of the debtor in possession model, which was predominant in the previous regime. However, in light of the recent trends in the law, one may infer that the law seems to go back to the earlier model. The main intention of the code, which was to protect the interests of the creditors, now it is going into the creditor run model, is currently being neglected in an effort to protect the interest of the company. Now again, there is a dilemma, because if you are going for the creditor centric model, then again you are going to place an hinder in the way of the company or small industry or small company. So there is a problem. This problem is still now unanswered. I am speaking about after the COVID-19 phase, because that point of time, 2020 ordinance, it was because the parliament was not in motion, so it came through an ordinance. It seems to have promulgated with the intention of protecting companies and promoters from no fault liability due to the COVID-19 pandemic and the ambiguities in the, because due to COVID-19 many banks gave that redressal to the companies, to the defaulters, and legislation seemed to raise more questions than answers. The ordinance must ensure not become a double-edged sword which has the potential to defraud or affect the interests of the small-scale vendors, MSMEs, and individual creditors who more often than not fall into the category of operational creditors, especially those whose credits falls below 1 crore rupee. Now from 1 lakh it is going to be 1 crore rupee, and the time period that we have mentioned about after COVID-19, there are chances that even their thinking is honest, they are morally they are correct, they are willing to pay, but they are the small industry, they are having bad times, they are the MSME, they are facing losses. So there are chances that, so now the legislative wing must ensure that section 10A, so that is a challenge for our legislatures for the coming days, but they have to think that how to make a balance, that whether they will go for the creditor centric model or for the debtor centric model. And I wish they will definitely find a way, and I am going to complete with this, that the legislative wing must ensure that section 10A does not become a tool for regaining the defaulters paradise which the enactment code sought to achieve. So when this particular code came into existence, that point of time, the entire country is a defaulter paradise. They have accepted. The legislature and adjudicating authority also need to be mindful in the implementation of the ordinance, which may possibly open a lot of floodgates to litigation on account of provisions introduced in the ordinance, providing an exemption period for defaults and restriction on filing of fraudulent or wrongful trading applications by resolution professionals, among other things. So to reduce that, now the government has to decide when the entire system is going or running towards Atmanirbhar Bharat. We are focusing on the small industry, micro industry, MSMEs. Now they have to make a balance how to give the priority to them also, as well as to maintain the legal as well as credit balance in the society, in the banks.
As you were talking about the post-COVID time, that is today, and the difficulties that we are facing, and especially as India is now the fastest growing economy, plus the highest number of registrations of startups that are coming up. It is from India that we are getting the boost of startups, various kind of startups. So do you think that what kind of in your opinion, what kind of a model, the creditor model or the debtor model, is more suitable for specifically the new startups that are coming?
Madam, the things are starting from 2013 Companies Act. If you can remember, section 6 of 2013 Companies Act is speaking for one-person company. If that was not done, or if that provision was not there in 2013 Act, then the particular processes of the Make in India, the processes of Atmanirbhar Bharat or startup, what we can see now, that how these models of Apple phones been developed in India, in some places in Bangalore and Hyderabad. So it is like a daydream, because it is only possible because one person company has given prominence by that law. Now, what we can say, yes, insolvency regulatory bodies and that particular system of IBC code came into existence. Now, model, it is my personal opinion that creditor centric model as well as debtor centric model, we have to think about both, and definitely those startups first, because nowadays startups, they are when they are asking for any sort of government support, anything, they have to show their model, and that model that should be accepted in micro level. So in that case, it is an urgent need of the time that what actually it is always not possible. I am not saying that 100 out of 100 like that, but in some cases when corruptions are there in this society, that models been accepted without going into the deep, and some models been even I am going to give one example. Just in about Northeast India, Tripura. Tripura is a very small state, like a bird pig state. We can say it is situated in the very cornered way. Three ways been that is gathered with this part, that is international border is there with Bangladesh and all. Now in Tripura, the tribal people they have generated some idea that they are going to produce that water bottles which are made up of bamboos. Now, okay, fine. That is also one thing. That is the protection of IPR is required. That is another part of law that is not come under the corporate sector, but yes, definitely that is go hand in hand. That the protection of their ideas, the IPR, the geographical indications, the various other aspects, and then the second thing that if it is going to be patented, then whether they are doing, they are interesting in it, they are able to establish a company, because if it is going to be a micro company, small scale industry, cottage industry, then what is the ultimate option for them? What is the ultimate means? What is the market for the product? So because earlier also the same thing happened, some industries been started and suddenly they are going to be stopped. So that is a backlash in case of the Indian economy, and it is not for today only. When India was under, I have mentioned in my presentation, was when India was not under the privatization, globalization, that era also, one particular part was SICA, and that was done by the parliament to deal with the government company when or small industries or cottage industries, because that time private companies were not much in this particular field. So ultimately, one thing I want to say that models, all the models are good, but making a balance between the things, and also to go what is practical, what is going on, which model will give me the best, which model will give my tradition, my knowledge into the society, into the entire world, that yes, it is India is having a comprised culture, it is having a multifaceted knowledge oriented people in it, so that must be shown off. It is not that only one or two people who are corporate, they are strong enough, only their models are going to be accepted by all. That I want to say.
I don't see, because sir, I will request one thing, that in case our any of our students they want to get access to your PPT, I'll request you to make a PDF document of your PPT and send us.
Yes,
so
yes.
Whoever wants to refer the PPT as their notes specifically, because it is made very elaboratively, and this will solve their notes problem.
I have shared also the PPT with you. Okay, I'll prepare PDF also if it is
PDF document.
Okay.
Yes, sir. So I think we come to an end of the session, and thank you so much, Dr. Chakraborty, for at least sparing time on a Sunday and allowing us to interact and frame this kind of because I always say virtual platform is a blessing in disguise. Because yes.
I will appreciate the entire team of Vidhi Varta for providing me this particular medium, at least to speak on this issue, because there are so many other areas of corporate law like Competition Act, non-application of that law, like corporate finances, even startups are there, even some issues of IPR. Nowadays, artificial intelligence been developed. There is another phase of law. Until now, artificial intelligence for our Indian system, it is a very new and it is not been regulated yet. So there are things, there are questions, but I hope in future also I will get the opportunity to make focus on these issues, on this particular things.
Absolutely, because I think, sir, today's youngsters and today's generation, as there is this trend of they want to own something of their own, and they want to do something different and not do a 9-to-5 job on a regular basis. They want to create something that is their own brainchild. I think this kind of lecture will boost their motivation, boost their their enthusiasm towards creating something that they want to.